Welcome to Ask the Expert with noted radio host Steve Sleeper. Each week, Steve interviews entrepreneurs and professionals and shares their intriguing stories of success and service. Now, here's radio veteran Steve Sleeper.
Our guest today is Benjamin Gerber, an experienced trial lawyer focusing his practice on helping those who've been injured on the job. He's also founding partner of Gerber and Holder in Georgia. Ben, how long have you been practicing law?
I have been practicing law in the state of Georgia since 2001, and my partner, Tom Holder, has been practicing since the mid-1980s. All we do is workers' compensation. All Tom and I have ever done since approximately 2004 is represent injured workers in the state of Georgia. I went off on my own in 2010 to found my own firm, and Tom and I joined forces in September of 2018 to form Gerber and Holder. Prior to that, I did personal injury work and workers' compensation work on the plaintiff side. And for the first 4 years of my practice, I worked for insurance defense firms, learning the ropes.
So, Ben, let me ask this question. What is workers' comp law, and then how do you help folks with that?
It is a law that is set in each individual state. So each state has different laws. And basically what it does is it protects individuals on the job when they get hurt. There is a trade-off for protection. The trade-off is if you get hurt in the scope and course of your employment, you can receive workers' compensation benefits, which are three things in Georgia. Indemnity benefits, which means wage replacement while you're out of work, medical treatment at no cost to you, and then ultimately you get a permanent partial disability rating, which is assigned by the doctor. The permanent partial disability rating basically assumes that you are 100% before you got injured, and they calculate the disability based upon that. So if you have a 10% disability as a result of your on-the-job injury, you are compensated for that. And there's a formula that the legislature has established to determine how much you're compensated. Now, the trade-off for getting those three things is that you cannot sue your employer in tort in the state of Georgia or in any state. For example, even if you got hurt on the job because of the negligence of your employer, you cannot sue them except for in the workers' compensation system. And you do not get pain and suffering in the workers' compensation system. That goes for all states. I have lots of clients that say, okay, where is my pain and suffering? Now that I've received my weekly checks, I've received my medical treatment, where's my pain and suffering? And unfortunately, you cannot get that. Now, the way I assist individuals is workers' compensation is a very dense area of the law. There are lots of rules and regulations, especially in the state of Georgia, that an individual has to follow. And if those rules and regulations are not followed, then you could lose certain rights. A very specific example is if you are out of work and you are receiving workers' compensation benefits, and the authorized treating physician, the doctor who was treating you, releases you to light duty work. Believe it or not, you do not have to immediately report back to your job. There are certain steps that the insurance company and your employer have to take to ensure that you are safe when you return to work. And if you just go back to work because the doctor released you, you could be giving up some of those rights, and you could be endangering yourself and ultimately your workers' compensation case. So we help people navigate the rules and regulations of workers' compensation.
So as we do this interview, Ben, we're right in the beginning of the COVID-19 crisis. How are you handling that? Are you open? How are you seeing people? All that?
Multi-part answer to that. We are open. We are working remotely, and we also have people in the office to receive mail and so forth. We are definitely, as a firm, social distancing. I happen to own the building where we practice, so no one else is in the office building, and I happen to be working in the office. So we are open that way. So there's a physical building that is open. All of the staff are working remotely. We have been paperless for 5 years now, so that wasn't a big change. Our computer system was updated also around 5 years ago, so everyone can access the cloud where everything is stored remotely. So that hasn't been a problem. The second part of that is we are taking every precaution to avoid our clients interacting with us so they don't pass COVID-19 to us, and we don't pass COVID-19 to them if we have it and we are asymptomatic. We are doing remote meetings with our clients. We are doing remote Zoom video chat depositions, which opposing counsels have eagerly embraced. The State Board of Workers' Compensation has recently stated that if you want to do a trial, you could do a trial by Zoom. And we have started partaking in those types of things. We've done mediations as well via Zoom. So we are wide open, and the State Board of Workers' Compensation is also open. So things are not stuck in Georgia. We are moving rapidly when it comes to what is going on to move an individual's case forward.
If I get injured on the job, can I go see my own doctor? And two-part question. Can I go see my own doctor? And how long do I have to file a claim?
Let me answer the second part first, and that is, how long do I have to file a claim? Nothing is easy when it comes to the laws and the rules and regulations of workers' compensation, so there is no set answer for that. It's a multi-part answer, so let's start with the beginning. You have 30 days to report your injury to someone on the job. Now, reporting is not a formal thing in Georgia. You can just tell a supervisor. So that first statute is easy to overcome. If someone saw you, that could be enough of a telling. So once you overcome that hurdle, there are three main statute of limitations. One, the first one, if you don't receive any workers' compensation indemnity benefits, meaning any wage replacement, and you receive no medical treatment paid for by workers' compensation, you have 1 year from your date of accident to file a workers' compensation claim. Now, what does filing a workers' compensation claim mean in Georgia? That's very simple. It means filing a form called a WC-14 with the State Board of Workers' Compensation, which is a notice of a claim. That's all that has to take place 1 year from your date of accident. Now, if you receive medical treatment from the workers' compensation carrier, meaning you go to a doctor that they tell you to go to, and you don't pay a bill for that, and that's covered by workers' comp, then you have 1 year from the last date of treatment to file a workers' compensation claim. And the final thing is, if you receive income benefits from the insurance company, or you are out of work because the authorized treating physician took you out of work and your employer paid you benefits anyway, paid you your weekly check is the benefits I'm referring to, you have 2 years from the last payment of those benefits to file a workers' compensation case. So it's not that simple, but basically you have either 1, 2, or 3 years to file a workers' compensation claim. And the first part of that question, in a workers' compensation case in Georgia, typically you cannot see your own doctor. Now, there are exceptions. If the insurance company has denied your case, then you can see your own doctor. And if you go to trial and win, you can have any doctor you want to, paid for by the insurance company. So you can see your own doctor. Typically, I would recommend against seeing your own doctor, because usually your own personal doctor is not a specialist, such as an orthopedic surgeon, who could properly treat your claim. So I would recommend not seeing your own personal doctor. If you really want to see your own personal doctor, I would contact an attorney, and they can walk you through the steps of how to see that doctor and make sure that that doctor gets reimbursed by workers' compensation.
How long does a claim take?
It's a question that we're asked often. A claim takes as long as you were injured, typically. If you were really hurt and you are not feeling well, and you cannot return to work, then the case could go on for years, decades even. However, if it is an injury where there is a finite beginning and end, then that's how long the claim will typically take. Now, all different types of injuries have all different kinds of timelines, but I would say a typical workers' compensation case runs between 6 and 9 months from beginning to end. We are considered a rocket docket, meaning if we file a request for a court date, we will have that court date usually within 6 weeks. Now, we don't always go forward before a judge within 6 weeks. We just have a court date within 6 weeks. And so when I say rocket docket, discovery takes place in a much truncated amount of time than a typical litigated personal injury claim.
So it's imperative to get in touch with you right away so that I can start getting benefits right away then, or as soon as possible.
Yes, getting in touch with an attorney on the front end of the claim allows you to be on the offensive as opposed to the defensive. There are many rights you are entitled to in a workers' compensation claim here in Georgia. For example, you are entitled to a one-time change in authorized treating physicians. Therefore, getting in touch with an attorney at the outset is very important so you don't change doctors to a doctor that is not going to help get you better in your workers' compensation claim. That happens quite often where the insurance company will initially send an injured worker to an industrial clinic who, quite frankly, doesn't do a great job of treating the individual. The individual says, I'm still hurting, and then they change to an orthopedist, and that orthopedist could be very insurance company friendly and not give proper care. So it is imperative to reach out to an attorney early on in a claim.
And what's the cost, Ben?
The cost in Georgia is that all workers' compensation attorneys work on a contingency fee basis if they're helping an injured worker. We are set by statute at 25% of the total settlement. So if an individual receives a settlement of $100,000, the injured worker would receive $75,000 and the attorney would receive $25,000. Now, let's be clear about two things. First of all, no matter how many attorneys you have in a workers' compensation case, the max that the attorneys can receive is 25%. So if you have one attorney and you don't like what they're doing and you terminate their services and hire somebody else, they cannot also get 25%. The attorneys are capped at 25%. Secondly, the State Board of Workers' Compensation in Georgia has to approve any settlement over $100. Which protects injured workers in the sense that any settlement is reviewed by an administrative law judge. And so there's a second set of eyes on any type of settlement. So there are protections for those that are hurt. Obviously, 25% is much lower than on a typical personal injury case, and even half of what a medical malpractice fee could potentially be.
Thanks to workers' compensation attorney Benjamin Gerber for being our guest today. His website is gerberholderlaw.com.
Thanks for listening to Ask the Expert with Steve Sleeper. Join us next time as entrepreneurs and professionals share their intriguing stories of success and service.